Welcome back. You're watching The Firm. Imagine the Competition Commission of India going after companies for tax avoidance. Well, that's exactly what's happened in the European Union recently. The European Antitrust Authority is now targeting tax schemes by member states. And Starbucks and Fiat are the first two MNCs to fall foul of the European Commission. So what did these two companies do that landed them in such a mess? And what does all of this mean for MNCs based in Europe? Ayush Alawadi finds out.
Today the Commission has adopted two decisions. They concern tax rulings granted by Luxembourg to Fiat and by the Netherlands to Starbucks. The tax rulings have artificially reduced the tax burden of both companies, and this is illegal under EU state aid rules.
Starbucks Manufacturing is based in the Netherlands. It sells and distributes roasted coffee and coffee-related products to Starbucks outlets in Europe, the Middle East and Africa. The European Commission found that a ruling issued by the Dutch tax authorities in 2008 gave a selective advantage to Starbucks Manufacturing, reducing Starbucks Manufacturing's tax burden by 20 to 30 million euros since 2008. The ruling permitted Starbucks Manufacturing to pay a massive royalty to Alki, a UK-based company within the Starbucks group, for its coffee roasting expertise. It also sanctioned an inflated price for green coffee beans to Switzerland-based Starbucks Coffee Trading SARL. EU's antitrust regulator says that because of this ruling, Starbucks was able to artificially lower taxes paid in the Netherlands.
What the concern here is that through intra-group pricing and corporate structure, a company is able to transfer funds within its business, with the result that those are not taxable for domestic purposes.
From a tax perspective, transfer pricing is a big issue for all multinational companies. They need to allocate the profits along the different places on their supply chain. Now, this particular investigation is into one small piece of the Starbucks supply chain. It's into Starbucks Manufacturing BV, which is a Dutch company, and what it does is it roasts coffee beans, which is not, frankly, a very complicated operation. Starbucks went to the Dutch tax authorities to get an advanced pricing agreement, an APA, to get certainty on their transfer pricing process. And that, again, is a very normal thing to do. So it's really surprising that the European Commission has decided to go into what's a pretty ordinary ruling into such depth. And I think a lot of us feel that the competition authorities are overstretching the mark here.
Fiat Finance and Trade is headquartered in Luxembourg. The company provides financial services like intra-group loans to other Fiat Group companies. The European Commission found that a tax ruling issued by the Luxembourg authorities in 2012 gave a selective advantage to Fiat Finance and Trade by allowing it to lower its capital base for tax purposes and show a lower return on capital as well. The European Commission says that without this favourable tax ruling, Fiat's taxable profits would be 20 times higher, and that the ruling helped Fiat reduce its tax burden since 2008 by 20 to 30 million euros.
The Fiat ruling is the tip of the iceberg in Luxembourg. You'll be aware that we had the Lux leaks, details of a lot of rulings in Luxembourg which have been issued over several years, and the feeling is that the Commission is looking in much more detail at Luxembourg. They were very irritated that in the Fiat case, Luxembourg refused initially to divulge full details of the ruling to the Commission, whereas the Dutch on Starbucks were very happy to give full details and to defend their position. So I think Luxembourg is on the back foot. They are noted for giving a lot of rulings around Europe, and frankly a lot of companies have got favourable finance rulings. So again, not clear why the Commission picked particularly on the Fiat one, and the feeling is that perhaps this is the first step into a wider investigation into other rulings given by Luxembourg.
The European Commission started these investigations in 2013, and last month it held that these two tax rulings are illegal. While these tax rulings by Netherlands and Luxembourg are legitimate from their tax department's point of view, the European Commission says that they amount to preferential treatment or selective advantage for these two companies, and hence fall foul of EU state aid rules. The Treaty on the Functioning of the European Union says that any aid granted by a member state or through state resources in any form whatsoever which distorts or threatens to distort competition by favouring certain undertakings be incompatible with the internal market. Experts say that the concept of state aid is very wide and can cover any economic advantage such as a loan at a preferential rate or even a tax break. State aid rules say countries have to first notify the European Commission before granting such advantages, which the Netherlands and Luxembourg did not do.
When that procedure has not been gone through and the advantage has already been given through a tax holiday or an advance ruling that a certain practice is acceptable, the beneficiary of the advantage, in this case the companies who benefited from the arrangements according to the European Commission, they risk having to pay back that benefit for a period of 10 years from it being granted. So you have a situation where, as a private company, a market agent who may consider that they could have received a benefit that is at risk under the state aid rules, they have to be assured through their dialogue with the government, the authority granting the benefit, that either there is no state aid at all or it has been notified to the European Commission and approved as compatible.
But tax experts are surprised at the scope of this decision.
It's very unusual and it's quite new. What you do see is the EU Commission looking at particular tax reliefs granted by countries. So, for example, if France wanted to give a special relief to steel companies because they're suffering at the moment, that would potentially be state aid. France would go to the EU and say, there's a particular reason, can we please grant this state aid? And the Commission would say yes or no. What's very unusual here is that the ruling practices are just part of the normal tax system of a country, and the Commission is looking in great detail and applying state aid principles to tax rulings. And what the Commissioner, Margrethe Vestager, said is that if tax rulings artificially reduce a company's tax burden, then they're not in line with state aid rules, they're illegal. So the question is whether this is an artificial reduction of a company's tax burden. And in the case of both Fiat and Starbucks, we haven't yet seen the detailed decision by the Commission. We've only seen the preliminary decision. The detailed decision has been issued, but it's not yet been published. But what they seem to have done is to have gone in great detail challenging whether the right OECD transfer pricing method has been used. I think that's going to get challenged.
The Commission has ordered its member states, Luxembourg and the Netherlands, to recover the unpaid tax of 20 to 30 million euros from Fiat and Starbucks respectively, to remove the unfair competitive advantage they have enjoyed and to restore equal treatment with other companies in such situations.
Well, we're already seeing multinational companies paying much more attention to state aid issues. So, for example, if a company is doing a restructuring or wants to look at their transfer pricing, up to now they've just checked whether it's okay for tax purposes, whether they can get a tax APA on it. Now they're also asking firms like Pinsent Masons to look at the state aid implications of that and say, if we get this tax ruling, is there a risk it could be challenged on state aid principles as well? So it's really moved up the radar for companies. The big problem they've got is if they've got a very favourable ruling from the past, can they still rely on that? And if there is a state aid challenge, that can claw back the benefits they've had for 10 years or more, which is a really big potential liability.
These rulings were granted in 2008 and 2012. We're now in 2015. So clearly cases are being reopened. Will this lead to a floodgate of more cases? Probably there will be further in the pipeline. The day that the Fiat and Starbucks cases were announced, Commissioner Vestager indicated that there were pending cases involving Amazon and also Apple.
It's expected that Fiat and Starbucks and both countries will appeal this European Commission decision on the grounds that this isn't a case of state aid, as they believe that no selective benefits were granted. That's at the general court stage, after which the European Court of Justice can be approached, which might turn out to be a long-drawn affair. But until then, one thing's for sure, Apple and Amazon will be watching these developments from the sidelines with bated breath. In Mumbai, Ayush Elavadi.
Well, before I say goodbye on the show, do watch a special edition of The Firm on FDI policy changes. We're asking if they were radical or incremental. The show will play out this weekend on CNBC TV 18 at these times. And here's some breaking news. The CBDT has released a discussion paper on phasing out all deductions under the Income Tax Act. You have 15 days to send in your comments, so hurry. Thanks very much for watching this edition of The Firm. We'll see you next week.
The Firm, India's only show on corporate law, tax and audit matters.